job. A man died this morning when he became trapped in machinery.
A man has been killed in a workplace explosion in Oakford.
A man has been killed in an horrific industrial accident. Shock at another workplace incident at the New Royal.
Throughout tonight's program, we'll be discussing industrial manslaughter and the liability of both the corporations and the individuals involved in these incidents, and speaking to relevant experts about the possibilities for future reform. Industrial manslaughter is a term that is used throughout the media when reporting on workplace deaths. But what does industrial manslaughter actually mean? There are many different definitions for industrial manslaughter, ranging from very narrow to very broad in their scope. A general definition set out under the Australian Capital Territories Crime Act is causing the death of a worker while either being reckless about causing serious harm to that worker or being negligent about causing the death of that worker. And now to Sarah.
On today's edition of TBC, we are talking about the extent to which directors should be liable for industrial manslaughter. Industrial manslaughter is circumstances of death caused in the workplace or death to consumers from industrial processes, giving rise to liability for prosecution for manslaughter of considerable seriousness. There are several legal issues when assessing to what extent the directors of companies should be liable for industrial manslaughter. Firstly, that the director of the company must be a contributory and substantial cause of the victim's death. Secondly, there must be gross negligence which can be traced to a particular director or manager. Difficulty in prosecution can arise where the responsibility is shared among many managers. This leads to the question of whether directors should be personally responsible for industrial manslaughter or responsible on behalf of the company, and which is more effective when prosecuting. I'm joined by Bethany, a criminologist specialising in industrial manslaughter. Thanks for joining me, Bethany.
Thanks for having me, Sarah.
So the extent to which corporations and their directors should be held liable for industrial manslaughter has generated significant debate in Australia and internationally. Why do you think this is so?
Well, Sarah, the community feels that allowing corporations to avoid criminal liability for causing death trivialises the value of human life. Homicide is one of the most serious crimes in the criminal law. Holding corporations responsible for causing death is paramount for the coherence of the criminal law. Within this debate, it has been said that the directors of a corporation aren't the people who should be held responsible for the deaths, as they aren't sufficiently connected to the decisions that are made in the day-to-day that lead to workplace incidents causing death. In large corporations, this debate may have some merit, but ultimately directors of a company have the responsibility of creating the conditions in which industrial manslaughter is likely to occur. Part of the debate, which is difficult, is whether industrial manslaughter can be regarded as a crime. Classing those offences that are covered by the OHS legislation as regulatory offences rather than as real crime. Real crime is seen as that of street crime, violent crime and burglaries, rather than the incidents of corporations. The crimes committed by corporations are cleverly referred to in such terms as scandals, disasters, abuses, and accidents, rather than as criminal behaviour. This use of language is strategic and may be due to the large corporations' power, control, and influence they have in society. If the literature on corporate crime shows anything, it shows that corporations do abuse the system and the law to commit crimes. When corporations engage in harm, this is represented as a deviation from the normal, well-intentioned routine, as opposed to deliberate offending. The evidence, however, would indicate otherwise. The differential treatment of corporations to their street crime counterparts offends the principle of equal treatment fundamental to the criminal law. The imbalance between how corporate crime is treated compared to street crime perpetuates that corporate crime is not a real crime and so will never be treated as one.
Okay, so that's very interesting. Where do you weigh into this debate?
I think that by being able to hold directors liable for industrial manslaughter enables the criminological goals of punishment to be met, these being denunciation, retribution, deterrence, and rehabilitation. These goals recognise the inexcusable nature of workplace death. The importance and the capability of the criminal law in these types of corporate crimes cannot be underestimated. The issue now is that corporate bodies and their directors being able to evade prosecution stirs feelings of injustice in victims' families and the community. Restorative justice needs to be considered both for the victims' families and the community. being compensated and being able to see real impact on the corporation after such a criminal wrongdoing helps to satisfy the families and the community that justice has been served. Satisfactory administration of justice, victim and community satisfaction for industrial manslaughter could be remedied through criminal liability for corporations and directors. Public pressure and dissatisfaction have been mounting with the inability to hold corporations and their directors liable for ongoing deaths occurring in the workplace. I can see this leading to the development of a harsh corporate-specific regime.
Okay, alright, thank you for that, Bethany.
Thanks for having me.
I am now joined by Tammy Franks, Green MP via satellite. In May of last year, she introduced a bill to the South Australian Parliament called the Work Health and Safety Industrial Manslaughter Amendment Bill. Tammy, thanks for joining us. Can you tell us more of what this bill is about?
Thank you, Sarah. Sorry I couldn't be there with you today. We need a pledge from governments across our nation and across the world to put their efforts into ensuring that every worker who goes to work comes back home to their loved ones uninjured and alive. Within the bill, an employer is guilty of an offence if the employer breaches their duty of care, the employer knew or was recklessly indifferent that the act or omission constituting the breach would create a substantial risk of serious harm to a person, and the breach causes the death of a person. The purpose of this bill is to improve the safety of workplaces in our state through the principle of corporate criminal responsibility. The bill was aimed at those employers who are indifferent, careless, or callous towards the safety of their workers.
So how does this differ from the current penalties?
There has been discussion that this amendment is not required because, as it stands, the current Work Health and Safety Act covers industrial manslaughter adequately. Currently, an officer can receive a maximum penalty of up to $600,000 and 5 years imprisonment. In comparison, the new legislation would enact a maximum penalty of 20 years in jail. In imposing a significant prison sentence, I want to prevent officers and directors from insuring themselves out of culpability. The penalty for the crime is punitive, as its purpose is to ensure that the punishment outweighs the potential benefits of committing the crime. There are flaws to having a maximum penalty. For example, a $2 million fine was imposed on Esso Australia after the death of a worker. While $2 million may seem like a significant amount of money, Esso was earning around $1 million a day at that stage. In this scenario, it is difficult to argue that the financial cost outweighed the financial benefit.
Where would this new legislation apply?
If this bill were to be enacted, it would apply in South Australia. As much as I would like to see a uniform act as has occurred in the United Kingdom, I just don't think it will be happening in our country anytime soon.
And now we're crossing live to Monique, our court reporter.
Thank you, Sarah. Today we are discussing industrial manslaughter and the extent of the liability so far in the courts. The Queen against Denbo and Timothy Ian Nadenbush was the first case in Australia where a director of a company was prosecuted and pleaded guilty to manslaughter. In this case, the corporation was argued to have failed to have adequate maintenance and train its employees correctly. The company was fined $120,000 but never paid as the company wound up before sentencing. However, Nadenbush was personally liable for $40,000 fine. Part of the reasoning to extend the criminal liability to Nadenbush was the acknowledgement of his responsibility within the company to provide a safe working environment for his employees. This decision is consistent with direct liability, or the identification model. The Australian courts started with the liability in form of imposing fines. More recently, in the Industrial Court of New South Wales, a term of imprisonment for 2 years was imposed. However, it was then suspended on the basis of good behaviour bond. This was in Inspector Batty against David Smith, where a subcontractor of a company was fatally injured in the workplace and the hands-on director, Mrs. Smith, was found liable. The reasoning for liability in this case was Smith failed to provide a safe system of work and failed to provide adequate training, supervision and instructions for installing safety measures. Today, if the courts find officers of a company are directly liable, they can receive up to a $600,000 fine and 5 years imprisonment. Back to you, Sarah.
Thanks, Monique. This is clearly a developing area of law at the moment. Ultimately, the desired development of the law is one that leads to the protection of workers by the corporations they work for and the directors that control the corporation. The deterrent for officers in implementing a punitive uniform system would be an aid in reducing the number of work-related deaths each year. Future research in this area should be a priority because one death is one death too many.